He felt like he was not going to get to see his son if he didn't do exactly what mom wanted. And I think the court has seen evidence of that when she withheld parenting time.
Your Honor, may it please the court, the respondent Cassie Hall appears in person. She's just off to my right here, just off camera. I apologize. We're working off a laptop today, and she appears with counsel Jessica Levitt.
Very well. This matter comes before the court at this time for review. Docket notes from the last hearing held on April 28th indicate that there was a PFA case to be heard in Sedgwick County on May the 7th. Court found that the mother's denial of weekend visitation was not justified. The father gets a make-up weekend visit. The father's denial of the child's location during the visit, in other words, where he was staying, was also wrongful in the view of the court, and he must disclose to the mother where the child will be staying. Ms. Smith was to complete journal entries, and then ADR with Mike Powers was ordered. Review hearing set for June 16th. I think that was later continued to today's date. So, Ms. Levitt, from your perspective, what is the current status of these matters?
Hold up, did you catch that? The judge just warned this could edge into criminal territory. That instantly raises the stakes. This isn't just unpaid money anymore. Would you gamble jail time over $35,000?
Judge, I want to advise the court of where we stand on the ADR because that has been a bear of a problem for us. So we reached out to Mike Powers for alternative dispute resolution, specifically mediation style ADR, and his availability when we reached out to him at that time, his earliest was a singular date of August 21st. Ms. Smith and I discussed that and decided that it was in the party's best interest. And in hindsight, we made a mistake. We will both own that. That is in the party's best interest to try to find somebody who could do end of July or early August mediation. We sent emails to, or I sent emails to all the mediators that I have used before. I have about 7 in rotation on a regular basis. And then there are several more that I'm familiar with their mediation, but they were fairly outside of the ballpark of these clients' income ranges. And we have found somebody. Ms. Ortega can do mediation with these parties at an affordable rate. She can do child custody, residency, parenting time mediation for between $1,000 to $1,500 per party. And she can do it, but her first availability is September 2nd, or the second week of September, excuse me. We are emailing with her about the exact date. There was only one mediator who was available earlier than Mr. Powers, but that was Joy Marlin. And I don't know if the court recalls this from prior hearings. Joy Marlin was the initial mediator in this case. And actually the paperwork for the parties from like their last order, not necessarily from this last round of hearings, but from their last order that actually memorialized their last go around, said that the party should return to mediation. And it specifically did reference Ms. Marlin as the possibility as the mediator for it in lieu of going back to court. However, Mr. Daughtry has objected to Ms. Marlin because of some issues within the paperwork that there's language that calls the party's parenting time shared residency, but then the schedule is not what the court would consider shared residency. It's not 223. It's not week on, week off. Mr. Daughtry has every other weekend. And he believes that was an error. And I have always operated from the presumption that if the parties have used a prior mediator or ADR coordinator and there was an issue with them that one of the parties raises, that it's better for the case and it's better for the objectivity of everybody to find a new mediator. So that was the path we took. We have found Ms. Ortega. It has significantly pushed the timeline back as the unfortunate reality of it. So in trying to get sooner than Mr. Powers, we put ourselves in a position to getting later than Mr. Powers, because when we went back to him, of course, August 21st had been taken from us by another family who decided to snatch the date and take advantage. So we do have a mediation. We're very close to being set with an exact date and time. We need to hear back from Ms. Ortega on her calendar. But Ms. Smith and I both agree to use Ms. Ortega. These parties just have limited means, which I think the court is very aware of. There were some mediators who were very immediately available. They were going to require a $2,500 retainer from both parties, though, which is just, there are families who can afford it. This family is not one of them. So we're trying to be realistic to their circumstances and what they can actually afford. And this is where we have come to as we sit here today. The makeup time did occur. The parties have figured out some vacation time between each other, which was a positive.
Ouch, she's saying if she didn't take his deal, she'd walk away with nothing. That's not a choice. That's pressure. Do you think she was cornered, or just cutting her losses?
Co-parenting change. They figured it out between themselves ultimately. So we are seeing some positive things occur in this case, but the mediation is the big piece, and it still needs to occur.
All right, Ms. Smith, what would you add to this?
Your Honor, I agree that we've agreed to use Miss Ortega, and my client understands that he's basically pushing it off, that we could use Miss Marlin and have it done sooner, but he would prefer to have somebody who didn't draft this parenting plan. He understands that that means that he's waiting until September in order to have that. Since he's the one asking to modify, we would just ask court approve that timeline since my client is making that choice. However, did want to inform the court that the PFA against my client was tried and dismissed. And so that is no longer at play. And so today, what I would just like the court to address is that the agreed parenting plan on file says that my client has parenting time on alternating weekends from Friday at 8 a.m. to Monday at 8 a.m. Throughout the history of this case, my client's parenting time has been whittled down by adverse party, where she said they have to meet after school at the police station. He can't pick him up from school, and he has to bring him back on Sunday. He can't keep him until Monday morning. And so we are asking that the court order that the parenting plan be followed in its entirety today that is existing, that gives my client every other weekend. He would pick him up from school. Obviously, he can't have him at 8 a.m. unless school is out. But he would ask that the court order that the parenting plan that is on file be followed in its entirety at this point while we wait on mediation.
Well, the kids aren't in school right now.
That's correct. But he's still having to get
for exchange, right?
But he's not getting him until 4:30 on Fridays at the police station, even though the parenting plan says that he should have him at 8 a.m. on Fridays. And then he's having to bring him back Sundays at 7 instead of Monday morning. So he's losing an overnight that is in the agreed parenting plan. And so we're just asking the court order that the parenting plan be followed in its entirety until we have mediation.
Which begs the question, why isn't it being followed now, Ms. Levitt?
By agreement of the parties, Your Honor. When the child started pre-K over a year ago, they shifted the weekend schedule to be a pickup at 4:30 on Friday for dad and return the child at 7 p.m. on Sunday. And in large part, that was because of dad's work schedule. He had to work Fridays. The child was in pre-K anyway, so an 8 a.m. pickup when the child starts school isn't realistic anyway. And then the Monday morning work schedule, the child has to be in pre-K in Augusta. This year it'll be kindergarten, of course, pre-K in Augusta, and dad couldn't get the child to school in the mornings. This was reached by agreement and followed as the de facto for a year. I will also tell the court, headed into this next school year, dad lives out. He gave the address to the court at our last hearing. He lives out in Mays. That's essentially with traffic on Kellogg. It's about a 40-minute commute from dad's house to the child's school before school. That adds 40 minutes to the child's morning. School starts, the child eats breakfast at school. He's allowed to have that because mom works there. They provide it to the kids, all of that. Those doors open for him to eat breakfast at 7:30 in the morning. My client works in the school district, lives down the street from the school. The child can leave for school by 7:15, 7:20, get there in time for 7:30. This is a huge shift to have Monday mornings with dad when a year ago, dad agreed to this change. I also would point out that we're going to mediation for a request initially filed by my client to change the schedule, but then a follow-up motion by Mr. Daughtry for shared residency. So now Mr. Daughtry is asking that this court revert back to a parenting plan that now hasn't been followed for a year, make that change right now, and then in September, make the change that comes out of mediation. That's a lot of change in a 60-day window to accommodate Mr. Daughtry essentially changing his mind as to what he wants to do on weekends. I would also point out that he has spent, since our last hearing till now, repeatedly complaining to my client about all the child's activities being in Augusta and about how far it is for him to get there for the activities.
What kind of activities are we talking about?
Like T-ball and summer things like that. The child wanted to do a soccer camp in Augusta, and it aligns the days for the soccer camp. The majority of them align with dad's vacation time. And my client said, hey, he wants to do the soccer camp. I don't really know exactly what your plans are for vacation. If there's a way for him to do it and you take him, I'd still like to sign him up. And he said, well, that's really far for us to take him every day to soccer camp. So it's too far in the summer when everybody has a flexible schedule and can do it, but...
Danger zone right here, non-stop texting a witness? That's skirting dangerously close to witness tampering. The judge isn't just scolding, he's making a record. One more slip, and this family case could explode into a criminal one.
Starting at 6:30, 6:45 in the morning during the school year, Monday morning, all of a sudden it's not too far. On a change that he made, that the parties have been following for well over a year.
All right, Ms. Smith, anything you want to say in reply?
Your Honor, my client objects that the changes were agreed upon. His position has been throughout this entire time that the changes have been forced upon him, where he did not have counsel, and so he felt like he was not going to get to see his son if he didn't do exactly what mom wanted. And I think the court has seen evidence of that when she withheld parenting time the one time he didn't do what mom wanted. And so he feels like he has been forced into this because he didn't have an attorney, that if he didn't agree to exactly what mom said, he wouldn't get time with his son at all. So he did what she said. The minor child is young. He gets up at 6:30, 6:45 at my client's house on a regular basis. So driving to school in the morning is not going to be a problem for that. And there's a difference between taking him to school one morning a week and being asked to come to activities several days a week in Augusta that are minor child. I mean, he could play t-ball with my client. And so there's a difference in asking him to come daily to Augusta for activities than him asking to be able to have the court-ordered parenting time. He would have to drive to Augusta one morning a week when the child is already awake at that time. This isn't asking the child to wake up any earlier. The child would be awake anyway. He's just asking to follow the court order that he's been prevented from following because he was fearful that he would just be taking his parenting time unilaterally, and he didn't have an attorney to defend that, and he didn't have the money to hire an attorney to defend that.
Pause, neither side looks great. He owed 80 grand and wants to settle for less than half. She agreed to forgive, then backtracked. So, who's actually in the wrong here? Whose side are you on?
And so this is the court order. The parties never signed anything else saying this isn't the court order, and he would like to exercise the full parenting time that he was awarded in this mediated court order.
This court disfavors daily long commutes for children to get to school. The school time schedule, which is currently being followed, makes sense, and it's in the best interest of this child. So the court will change the school year schedule to 4:30 p.m. on Friday to 7 p.m. Sunday. However, we're still in the summer. To the extent that there are existing weekends for the father that would not be affected by a school schedule, the prior schedule should apply. In other words, the expanded schedule from Friday morning to Monday morning, because it's not going to impact any school attendance. So essentially, both parties are right in their own way. The existing parenting plan should be followed until it interferes with the commute to school. And I don't know exactly when his school starts in the fall. It seems to start earlier and earlier each year. But I presume that there's some part of July or August which the father will exercise one of these expanded weekends. And so the existing parenting plan order would apply to these summertime weekends. Do you need any clarification on that, Ms. Smith?
Your Honor, can my client pick up the minor child from school on Friday afternoons instead of meeting at the police station? That wouldn't be a
Why are
commute
they
to
meeting
school.
at the police station?
That was, again, per mom's request, and if he's gonna have 4:30 at Friday, there's no reason he can't just pick him up from school on Friday afternoons.
Judge, we don't have any problem with him picking up the child from school on Friday afternoons, but it wouldn't be at 4:30. He'd have to be able to be there when school let out, which is 3:15.
Is that a possibility for him? Can he actually be there physically to pick up the child at 3:15?
Yes.
Well, again, that makes sense. And it appears to be certainly consistent with the best interest of this child. So yes, he can pick up from school. All right, I'll need an order drafted stemming from today.
Your
Ms.
Honor,
Smith,
I'm
you
happy.
wanna do
I'm
that?
happy. I can
Okay.
draft it, actually.
All right.
I'll do it because Ms. Smith drafted the last one, so.
All right. Backing up a minute to Ms. Ortega's involvement in this case, I wrote down September 2nd. Is that a date she is available?
Your Honor, that was a misstatement. The second week of September. I'm sorry, not September 2nd. That was a flub that I said.
All right, but she is going to be available sometime during the second week of September.
That's what her email to me yesterday afternoon said. I'm going to do a new email with Ms. Smith on it so we can go on the back and forth on the calendar and pick the exact date.
All right.
And Ms. Smith
Including
and
the
I have
order.
already discussed our need to clear our schedules to make it happen, because otherwise we're going to be looking at, with what our other mediators said, end of September. Even some people said they weren't available until October, and we just can't have that.
All right. Include Ms. Ortega's agreed upon designation of the mediator in this case. And I trust that she will be conducting traditional mediation.
Yes.
All right. The court doesn't want to let this case go without setting another date for review of its status. What would the anticipated length of time for mediation based on your knowledge of how Ms. Ortega does things, Ms. Levitt?
I'm sorry, Judge, could you repeat that? I apologize.
What's the time frame for mediation reasonably expected from Ms. Ortega?
She believed that we would only need one session of mediation, that we could look at either a half day or a full day, but that one session would do it because counsel is going to be involved in this mediation. We believe that the extra oomph, for lack of a better word, of having Ms. Smith and I there is necessary for this mediation to be successful and productive. And so with that, Ms. Ortega thought a half day or a day, but certainly not 2 sessions. And so if we could have a review hearing, I don't know what the court's availability is, but towards maybe the end of September, that would give us time to do it. And then, provided that agreements are reached and it's not a complete failure, which neither Ms. Smith nor I anticipate it being, we would have time to also memorialize what comes out of that.
What's counsel's availability like on the morning of Monday, October 6th?
I believe I'm available, but I'm going to double check so that
Please
I
do.
don't miss one.
Ms. Smith?
I can do the morning of the 6th. I'll be out in the afternoon, but I can do the morning.
As will the court. So
I'm available all day, so whatever is fine on the 6th.
all right. Let's review this case at 11 o'clock a.m. on Monday, October 6th by Zoom. I encourage, though not requiring, the presence of the parties as they have today. I do appreciate them personally attending these Zoom status conferences. Monday, October 6th, 11 o'clock for further review of this case by Zoom. And hopefully there'll be an announcement of some progress that perhaps has been made in cooperation, which has been negotiated between the parents, which I encourage the parties to continue to work together for the best interest of the child. Again, Ms. Levitt, if you'll draft an appropriate journal entry stemming from today's review hearing. Ms. Smith, is there anything further that the court needs to address at this time?
No, Your Honor.
Ms. Levitt, anything further currently?
Nothing further, Judge.
Very well. Then if there's nothing further, this matter will currently be in recess.